Back with another one, folks. Attorney Mario Santos. I have the esteemed colleague here from our team, Mr. Daniel Rodriguez, sitting right across from me, fresh off a not guilty verdict out of Brazoria County, by the way. Really difficult, I would say, because it's certainly something where Brazoria County, we have extreme respect for the prosecutors out in Brazoria County, but they're conservative, right? And so if you guys know, if you've been following us here, you know, our focus within Houston is really handling Houston itself, providing great quality service, but we also provide that same high quality service to the contiguous counties to Harris County. By that, I mean Harris County, Galveston County, Brazoria County, which is south, Fort Bend County towards the west, Montgomery County towards the north. We also have Waller County and Chambers County. Chambers County is a little bit more towards the east, but these are the folks that we tend to make sure that, hey, look, if you guys need us, make sure you know about us, because we want to make sure that we provide that high quality service. No, in this case particular, Danny, we had a client reach out to us and say, hey, look, I've been handling this case myself, which is rare, by the way. We said, wait a second, what do you mean? Pro se. Pro se is a legal term that really details an individual having the opportunity to represent themselves in a judicial proceeding. Here, specifically, this case involves a criminal allegation, and the criminal allegation involved unlawful carrying of a weapon. Matter of fact, I think it was 2 weapons, if I'm not mistaken, correct?
Correct.
Danny, enlighten us a little bit more with the facts and the circumstances so we can, of course, educate our audience here and make sure that they understand fully what happened.
Right, so I'll provide some brief background about this case. One, from you correct when it comes to pro se defendants, it is something that is a little rare, but at the same time, it's also that we really do not like to recommend folks to, go and try to handle these things themselves. There's a lot of things, especially nowadays, Mario, when it comes to like Chatgpt, AI, all these things. Maybe folks think, hey, I just put that in there and maybe it can tell me what to say, tell me what to do, things like that. And so we do want to make it, abundantly clear to folks out there that it's like AI is, a tool, and it is growing in sophistication, but it's definitely not something that we would recommend, people out there to be like, hey, I'm going to put everything on AI and then see if that sticks.
Important to note on that, especially when you're looking at possible jail time, when you're facing a criminal allegation, you don't want to just simply place your entire trust on a software that potentially cannot actually step in the courtroom, discuss, advocate on your behalf, specifically towards a judge, towards a jury. So be very mindful about that. Certainly resourceful, it's useful, but when it comes down to actually presenting to a jury, you want to have a strong advocate on your side. Okay, so on this situation here, Danny, let's learn a little bit more about the facts. What happened?
So in essence, there's 2 things that have to be taken into consideration. And one of the things is when we ultimately got attached to this case. Right. So we pretty much got attached at the tail end. This case had already gotten sent, was already ready for trial.
Yep.
And so all of the pretrial hearings, arraignment, all of that stuff had already happened. Certain things that we could have used to try to push for dismissal or try to get the best resolution for our client, we had lost basically all of that time. And so we had to turn it around really quickly, and which we did. But ultimately what ended up happening with the facts of this case is that our client was being charged with unlawful carrying of a weapon, UCW. There's a couple of ways that you can get there. In this particular case, the allegations were that he got to unlawful carrying of a weapon because he was allegedly intoxicated while carrying these weapons.
In a public place.
In a public place. And so all of that was something that was contested, but the majority of it, once we saw the facts of this case, we were like, you know what, like there really is no reason to be like, he's in a public place, he's doing this. All we want to focus on is the intoxication part, because that's where we saw that the state had definitely missed the mark. And again, just want to reiterate to folks out there, which is this is something that, had it been caught early on our side, had we been there from the very beginning, that's something that we would have hammered on and focused on from the very beginning. And ultimately, right, we're very, satisfied, and our client was super happy that we were able to get this resolution. But I mean, if we could have gotten this resolution a lot earlier, I'm pretty sure everybody else would have been happy.
It's so important to take diligent action as soon as you have the proper understanding. Whoa, wait a second. either one, I've been placed under arrest, or a loved one, a family member. But second, you actually have been formally charged. You want to make sure that you have, as I mentioned, a strong advocate on your side. Why? As Daddy just stated, potentially we could have resolved this, a month in, 2 months in. We don't know, but we have to make sure that we're taking diligent action compared to the understanding of, well, let me try to handle this myself. And now we have a situation that stretches out. You're stressed during all of this time, by the way. Why? Because you're facing possible jail time. But the main concern also was, well, wait a second. I mean, I purchased this weapons, because I think there was more than one.
Right.
I purchased them lawfully. I had them concealed, which in Texas, if you guys understand the law allows you to carry without actually having to have a license to carry. And in this situation, our client, was exercising his rights. He had these weapons concealed. It was not just simply out for anybody to see or observe. However, as Danny stated, what really caused the situation to become unlawful carrying of such weapons was that the state of Texas alleged that he was in a state of intoxication in a public place, which would be public intoxication. So with that being said, it's a Class C misdemeanor for the public intoxication, but because they focused on, wait a second, we discovered weapons once we actually arrested this gentleman, it becomes an unlawful carrying. It's a lot more serious in your Class C. And so they focus on the serious case. They didn't even charge him with the public intoxication.
So that was one of the things as well that going a little bit into the facts of this particular case is that he was a person who understood his rights. And he was like, hey, I'm totally able to do this. And the officers had told him, hey, just go home. And he's like, I don't have to go home. I have no reason to. I'm not intoxicated. I'm not doing anything here that's illegal. Why are you questioning me? Why are you detaining me was the main issue. And ultimately, it was a rush to judgment from, at least from our perspective, it was a rush to judgment from law enforcement side. In essence, once he knew that he was, in essence, going to be, taken in, he's like, hey, I just want to let you guys know I have weapons on me. He was completely courteous to them, respectful, and all that nature with them. But ultimately, they were like, well, we got you for intoxication. And ultimately, when I say intoxication, that's where we get into a little bit of a gray area, Mario, because when we talk about PI, like the
Public
definition, right? Public intoxication, the definition is that you become somewhat of a danger to yourself or to others. And once you hit that threshold, then ultimately the state can be like, well, if you're a danger to yourself or to other people, then at that point, that's enough for PI. Now, when it comes to DWI, it's a little bit more difficult to get into proving intoxication. There are 3 ways to get into intoxication.
Which are?
So the first one, and the ones people know most, is that their BAC, their blood alcohol concentration, was above 0.08. Usually, for something to be able to prove that, you are going to need maybe some blood, breath, something of that nature. And then there's 2 other ways, which is that you lose your normal sense of mental or physical faculties. And so that's why we have the standard field sobriety tests, and it involves, drugs, alcohol. There's a thing called the DRE that they're able to use there.
Okay.
But in this case, they didn't do either. So they're like, okay, so we know what intoxication means on the DWI side, and we know what intoxication is on the PI side. And so ultimately, what we were all wondering was, or we were telling the judge, is what definition should be used for purposes of this trial, because when you look at the statute for unlawful carrying of a weapon, it doesn't define intoxication.
Right.
And so there was a little bit of a legal battle there where the state wanted to use that he was a threat to himself or other folks. And we were of the position of like, well, this is a lot, like that's a Class C misdemeanor. A DWI is a Class B. Unlawful carrying of a weapon is a Class A. So we're arguing that, it should be more of
Elevated.
a DWI kind of definition or something similar.
Right.
Ultimately, the judge decided, he's like, well, I'm going to let the jury decide. The jury's going to decide what intoxication means to them.
Now, that's important to know because, look, and mind you, by the way, Danny tried this case with our other associate attorney, Mr. Corian Johnson. And the thought process here as preparation for the trial itself was, well, what exactly would be the angle here? What would be the issues? And we determined intoxication is going to be the main issue.
Right.
Can they actually prove intoxication so as to then make this a situation where our client was unlawfully carrying this weapon? So, with that being said, we fleshed out, okay, well, what do we need to actually have, really come out during voir dire? And I think there was a situation where at one point we discovered, wait a second, there's someone on this panel.
Right.
And enlighten the audience, what happened specifically there?
So I thought that was pretty interesting. So ultimately, once we do the voir dire, which is basically jury selection or jury deselection, the jury selection process, it's an opportunity where we get folks from around that particular county, and then we're supposed to select, right? And I say select, but it's really just deselect. But we get to deselect the jurors that might have a certain bias. Maybe they're not adequate for that particular role, or maybe there's something else. Maybe, for instance, they have some medical issues that won't allow them to continue on with the trial, or maybe they have something with their job or some things like that. When we can all agree, you know what, this person doesn't really want to be here. Let's just strike them and things of that nature. But that is the first time that we get to actually see the potential jurors, because it's not the actual jurors that are going to be selected, but we get to see a whole,
The veneer.
yeah, the veneer, that's what they call them. And so in essence, we see these potential jurors, and we're able to introduce ourselves, introduce our client. And so that's the perfect time for us to get up there. So I got up there and I was like, hey, introducing myself. I have the absolute, pleasure of representing my client here alongside my co-counsel, Courtney Johnson, and get to feel about, what are their thought processes. And I kind of seen that they were a little bit befuddled about, wait a minute, what do you mean intoxication? Like, how can intoxication, you can't define it for us? And so we ultimately were like, exactly, that is our problem here. That the state just, one, the court will not define it. The state wants to go with this PI side. But ultimately, it's like, what do you guys think? Because if the judge is giving you this ability to decide what it means, then we want to make sure that we talk to these folks and see ultimately what intoxication means. And so we saw a couple of people saying, well, I think that if you drink one drink, you can be intoxicated.
Mm.
And there's other folks that were like, hey,
Lightweight,
I don't drink. I think that you should just not drink and carry a gun. And some folks were like, I don't think you should carry a gun whatsoever. And so all of these folks are people that we're keeping an eye on, maybe striking them out for cause, or maybe we want to do a preemptory strike. And, one time, maybe one day we'll do a video about, the whole voir dire
process.
But just for this purposes here, in essence, there was one specific person in this pool who was an actual prosecutor, a DA in that specific county. And ultimately, I was like, well, wait a minute. Like, he has likely handled DWI cases.
Mm-hmm.
And so everyone here's talking about what intoxication means for them. I'm like, well, first of all, I'm going to strike this guy no matter what. He's definitely not making the jury. But I'm like, let me see if I can try to utilize him for purposes of kind of opening up the discussion about what intoxication means. Right. So ultimately, I felt, hey, yeah, you're here. I just have a couple questions for you. I heard some of the things that you said with regards to when the prosecution, the state of Texas, was up here asking a couple of questions. And so I simply asked him, tell me about the DWI process, what intoxication means. What is it that you're looking for? And he goes on and he's like, you could tell he kind of didn't want to give me too much, but he's like, well, we do breath, we do blood above 0.08, everything that we're talking about, the mental physical faculties being lost. And I'm like, how do you get there? What do you guys test for? And he's like, well, we do. And he kind of didn't want to tell me. So I'm like, well, you guys do standard free sobriety test, right? He's like, yeah. And you do the walk and turn. And I started doing the steps. It's like, yeah, we do. And you do the one leg stand when you have people, raise one of their legs. It's like, yes. And this is just to see if they're intoxicated for purposes of the mental or physical faculties. And then we have the 0.08, and he goes through the whole process. And what else do you look for as a prosecutor? What do you look for to prove just intoxication on the DWI side? Because he wanted to stick to PI.
Right.
He's like, well, we look at receipts, we look at, videos, we look at, anything that maybe they said that they had something to drink. And I was like, perfect, thank you so much. Would anybody else agree? And people got up and they agreed, and we took note of who they were. And then once we were done and we selected our jury, the first thing we do during opening statement is, in this particular case, you're not going to see receipts. You're not going to see any videos of him drinking. You're not going to see any statements made from his part that he had drank. You're going to see that the officer didn't conduct any such investigation. And it was just such a quick rush to judgment where the officer was just like, I'm just going to take you in. And in essence, once we said that to the actual jury, I believe they were like, wait a second, this is weird, because from their perspective during voir dire, they had noted, they're like, well, I mean, if there really is no definition for intoxication, then, and I remember this, one of the jurors, ultimately did say to the prosecutor, it's like, I think you're intoxicated right now.
Is that the case?
I'm like, if you can't tell me, and it's like, exactly. And so we honed in on that, and we made that a huge issue.
Now, mind you, what you just described here, Danny, is what I would label as seeding, meaning seeding other potential jurors by really having one particular juror open up, plant the seed to other potential jurors as to what it is that they should be looking for, what kind of evidence truly should be presented by the district attorney's office or ultimately the state of Texas, so as to then be able to prove beyond a reasonable doubt in a court of law the allegation that has been charged.
Right.
And so with that execution, honestly, I think you, Mr. Johnson, beautifully executed this, because my understanding, correct me if I'm wrong, once closing arguments were presented, jury gets the order from the court to go into the deliberation room. They get instructions as to, how to go about getting to deliberate. They need to have a assigned foreman of the jury. And the understanding was it may have been 20 minutes at most.
Mario, we had walked to the deli. I ordered a sandwich, and I had taken like 2 bites into that sandwich when we got that message that the jury had.
Verdict is in.
Correct.
What was
We're
that
like,
verdict,
okay.
Danny?
It was not guilty. Beautiful.
Client at that point is extremely happy. These are the things that, prospective clients out there, they need to truly understand. Look, you guys need to have somebody who has the proper experience, understands the judicial process, how the system works, in order for us to hopefully then, one, avoid the need to actually have to go to trial, but more importantly, to have the ample opportunity to really flesh out the entire evidence, understand the totality of the circumstances, and if we need to, just like we did here, execute accordingly and get to that W. In this case, not guilty verdict, by the way, is the best result possible for any criminal allegation, aside, of course, from the dismissal. But with that being said, congratulations, Danny. Any words here for our audience before we let them go?
Just thanks for having me.
On that note, we'll see you guys on the next one.